I'd now like to call upon Mahat to share.
When I was sent the questions on what to discuss, they were too hard, and I'm finished with school. So I told Prof, I'll just discuss my experiences as a legal practitioner on the nuances of law. The first bit is, I have seen languages or the nuances of law and the language, especially the English language, determine a presidential election. I have seen determine the fate of a criminal complainant. I have seen also being used to also determine a political process. I was involved in an election petition from in 2013 and 2017. And I think a lot of Kenyans saw the Supreme Court proceedings going on, and there was a lot of drama about it. And if you read, for the keen student of language and the discussions I've been having with Professor Mbote and Professor Mugane, if you are a keen student of law or language, you will actually realize that the determination of that petition related to a very nuanced, small bit of law. And I'll want to read to you. Section 83 of the Election Act states that no election shall be declared to be void by reason of non-compliance with any written law relating to that election, if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in that written law, or that non-compliance did not affect the irregularities. And I have the judgment here. If you look at the discussion of the judges from paragraph 192 all the way to 211, it just related to how do they interpret that provision. Do they interpret disjunctively, or do they, which will have a very different outcome, or will they interpret conjunctively? If you look at paragraph 211, the court states that the two limbs of the section should be applied disjunctively, which means that if a petitioner is able to prove that the election was conducted in substantial violation of the principle of the Constitution, then he will be successful. Or if he is not, even if someone is able to prove that it was conducted in compliance with the Constitution, but still you have some irregularities, you will still be successful. So, and the court made a lot of discussion saying that in the Raila 2013 decision, the court did not apply conjunctively, which meant that you had to do both ambits of the law. So if you look at that aspect of it, it was a very profound thing for me, because an or, a small word like or, has a profound effect on how you actually determine something as big as a presidential election. And the professors of language, you should look at that judgment and come to that conclusion, because there's a lot of hullabaloo about it, but the whole thing turned on that bit. The second thing is, as we were litigating, one of the senior counsels made a profound statement. He said, the use of the provision shall can mean something to be done in future. And the court and everyone was actually laughing. That's Fred Ngati, I was with him. And I really looked, and I went back and I talked to Professor Mugane, and I told him, the way the lawyers have been socialized is shall mean something that is mandatory. But in common parlance, I shall do this tomorrow. I shall be able to do something next month. Shall can also mean something that you are planning to do, or that is something in the future. But for most of the lawyers, whenever they hear shall or may, it's something that the way they have been socialized, or the way they think the interpretation should be done, is something else. So there is a lot of disconnect between what you actually have in terms of the legal language, as I may call it, and the common language. Sometimes that will be invariance. The second bit that I wanted to before the time is over, law, or the language of the law, can be used to actually determine policy questions, can also be used to determine political or paternalism. For example, in 2008, during the time of the bailout, there's a professor of mine at Harvard, he taught Nkatha and also Dan Juma, Carl Sunstein. Carl Sunstein was hired to be the regulatory affairs director for Obama White House. And one of the problems they were facing was the bailout program. References of words such as toxic assets, trouble assets, were so revulsing to people that a lot of the Americans did not want in any way to use taxpayers' money to actually do this bailout. So one of the advice they have been told is, they have been told the reordering of the legal or the language that the people are giving out to the public should be reordered. For example, they said, we will call this as a federal bailout. We will call it as an American reinvestment program, okay? And a lot of research that has been done on it, there's been a lot of psyche changes on how people look at those programs when reordering in terms of the language that are used for those matters are actually done. And there's a lot of that has been done about it. So, for example, you want free markets, you want liberal economy and everything, you want freedom, but people have a lot of biases. So language can be used to actually guide people, okay, to make choices that are good for them, even though with their biases and quirkiness and everything they have in the way we actually reorder about it. The third and the most important one is in the criminal law process. I've done quite a bit of research on this with Professor Mugane. 80% of the court interpreters are not trained, they are lay people. The criminal language is very different from the common language. The intermarriage and the intersection is very problematic. 80% of the people who are discharged or who convictions are not gotten are people who are because of the language problem, either in terms of interpretation, in terms of plea taking, and in terms of all these things. So it has a lot of issue as a lawyer. Oh, I have 0 minutes, 1 minute. So it has a lot of problems in terms of the criminal process. And the criminal process is very in the code, and it's very elaborate on how the language or the legal problem, the legal should be handled. 99% of the time it's not handled properly, and if you look at any court process or anything, you will see that. The third and the fourth one is on contracts. For the practitioners, they know this. Contracts drafting is all about language and how you use it. There is a difference between reasonable effort and best endeavors. You will be told that. There's a big problem. There's a problem when you use or and. The way you people draft, or when you're writing your paper, you might think that those are connectors that are the same. You will be told there's a very big difference between using or and there are a lot of nuances in contracts, and most of the time they will be able to do that. And generally, the legal question is very different from the normal language problem. Mudomi will talk about this. There's a video he has sent us in a group. We graduated with him in a group on the use of a word Xerox and a photocopier. And there was a lot of things going on, and the way people look at it, for a lawyer, you know a photocopier and you want someone to admit that they know a photocopier, but some people don't even know the word photocopier. Some people call it Xerox or the machine name or whatever they will call it, and you will always have a problem between the language that is used in common parlance and the legal language that is used by people. So there's always that problem. And the way to actually bridge it is, and I always tell people, lawyers are very bad draftsmen. They are very poor in languages and in their syntax and in everything. Probably we need to retrain all of us. I mean, I'm always looking at when I'm training my lawyers, I say, why are you using this as a verb? This is a noun. And most of them will tell you, what is that? What is because of the way they have been socialized. I mean, the legal language has become overarching to the normal syntax language, whether it is English or in the mother tongue or everything. So maybe we might have to be retrained in the normal language before even we start talking about the legal language.